So what you cannot do directly, you cannot try to do it indirectly also. This is how in one line we can explain the doctrine of colorable legislation. What this means is that if Constitution does not allow any action to be performed, then that action cannot be performed indirectly also. Now this concept is usually used by the judiciary to decide the legislative powers of parliament and the state legislatures. Now we know this, that we are a federal political system in which the powers are clearly divided between the center and the states by way of three lists given in the 7th schedule of the Indian Constitution. Now although these powers are clearly divided, but what may happen is that a legislature may try to legislate on a subject which does not fall within its legislative competence, and then it can try to justify that piece of legislation by arguing that this legislation is on a subject which falls within its legislative competence. Let us see how it can play out. Now let us say Parliament. So we know that the Parliament does not have legislative competence to make laws on subjects of state list. That means directly Parliament cannot make law on subjects of state list. Now what may happen? That Parliament deliberately or otherwise may happen to make a law, and let's say this law is on a subject of state list. And then what Parliament may do, right, or may try to do in the court is that this law may be given a color, this law may be given a facade, it may be given a disguise of a subject which falls under the union list. And then when the matter goes to the court, the Parliament or the central government may justify that this law, which is actually on a subject of state list, is on a subject of a union list. Let us see an example. Now we know that the subjects of police and public order, that means law and order, are given in the state list. That means the laws on the police and law and order are to be made primarily by the state legislatures, and directly Parliament cannot interfere in these subjects. However, I am sure you guys have heard of something called as Armed Forces Special Powers Act 1958. Now in AFSPA, in section 4 of the AFSPA, certain special powers, that is why the name of the law, Armed Forces Special Powers Act, certain special powers which actually belong to the state police, like the power to arrest a person who is accused of committing a cognizable offence, the power to search a premises, the power to stop and search vehicles. Now these powers are usually available with the state police forces or other investigative agencies of the central government, but not to the armed forces of the union, such as the Army, Navy, Air Force, CRPF, BSF, CISF, etc. So now in AFSPA section 4, what the Parliament has done, it has made a law in which certain special powers have been given to the armed forces of the union. Now these special powers actually belong to the powers of the police, and therefore what can be the allegation by the states? Allegation can be that this AFSPA is actually a law which Parliament says is on subject of national security, right, or anti-terror law, but the states may argue that this is a law which overlaps with the police and public order, and therefore Parliament does not have legislative competence to make such a law. Take another example. Let us say National Investigation Agency Act, NIA Act 2008. We all know this act was enacted by Parliament in the immediate aftermath of the 26/11 Mumbai attacks. The purpose of this agency is to investigate any case related to terror attack, attempts of terror attack or terrorist funding. And according to the NIA Act, once a case is taken up by NIA under its jurisdiction, the state police of that concerned state will no longer have powers on this matter. Now this again infringes upon the subject of the state police, and that is why in 2020 the state of Chhattisgarh, the state of Chhattisgarh has filed a petition, has filed a reference in Supreme Court arguing that NIA Act is unconstitutional because it is an act of colorable legislation. Colorable legislation. Because Parliament has made a law on subject of police, but it is trying to give it a color. It is trying to give it an outer appearance of a subject which comes within the competence of the Parliament. Right now the matter is pending in the Supreme Court. Now remember, while deciding whether a law is colorable or not, the main thing which matters is the competence of legislature. The competence of legislature, and not whether it is a bona fide law or it is a mala fide law. That means intentions of legislature do not matter. What matters is whether the legislature has competence to make that law, and competence here means mainly in respect of two things. First, it means in respect of division of powers. Division of powers. And second, it means any other restriction made by Constitution. For example, the legislatures do not have the competence to make a law which violate fundamental rights or other parts of Constitution. So directly you cannot make a law which violates fundamental rights, but the legislature may attempt to make a law indirectly, then that also will be called a colorable legislation. I hope this doctrine is clear, and you can attempt any question from this doctrine in prelims or the main examination. Thank you.